And so thank you for being here. We have two people here in our office, and we have one person online. We just restarted these presentations. We did them pre-COVID, and then during COVID for a while, and then people got tired of that. So we halted and have just restarted. And we've got a little bit of a new format. We're doing a fairly brief 20-30-minute presentations and time for lots of questions. Over the last several years, I've done a lot of presentations to various organizations, the Autism Society, Parkinson's Support Group, to the school districts and so forth. So I really enjoy those, and we always get a lot of attendance at special needs presentations because there's just a lot of interest in it. So today we're going to talk about a little bit about celebrities. Everybody likes talking about celebrities, and we've had a lot of conservatorship or celebrity issues in the last couple of years, especially this last year. And then we'll talking about the types of various conservatorships and financial powers of attorney and so forth. So you go ahead and admit them. Okay. And so, anyways, let me introduce myself. And well, first, the classic disclaimer. The following presentation is for legal information and legal advice. So why do we say that? You always hear attorneys say that, because a factual situation can really turn on what sort of advice we provide. And that's why we present general information.
The conversation.
It is, that's right. So I want to talk about conservatorships, and so what is the definition of a conservatorship? A conservatorship is the position of being legally responsible for the care of someone who is unable to manage their own affairs. So basically, it's the government taking the rights of somebody and giving them to somebody else. In most states, it's called a guardianship. Here in California, we do everything different, and so we call it a conservatorship. Conservatorships can be used for good or evil. They can be used as a shield or a sword. And I think we have two examples here that happened relatively recently, which I'm going to get into, which I find very interesting. Maybe most of you know of Casey Kasem. He was a famous radio guy, did America's Top 40s and so forth. They made a lot of money during his career. I think he ended up being worth $80 to $100 million. As he aged, he came down with a form of Parkinson's called Lewy body disease. He was, of course, married, had several kids, then had a second wife, had another child. But as he got older, he started drastically limiting the visits by his children. He went a lot of the children to visit them. She was hiding him, moving him from hospital to hospital, then moved him up to Washington, and several years passed. So, it was like, what was going on? Obviously, the family was very concerned about this. Inadequate care. Was he receiving the right care? Was there an evil motive? Unfortunately, when you have things like 80 to 20 million dollar estate, people get greedy. And so at one point, the children formally reported him missing. Eventually, they obtained a conservatorship through the courts and were able to get control, brought Casey back to where he was at, lived a couple of years, and eventually passed away. I think that in this situation, the conservatorship helped Casey's quality of life because it got him away from the evil person. There was a lot that we never quite heard what resolved. The second wife accused the other. He passed away quite a few years ago. But the second wife accused him of the family members of going after his money, and the family members accused the second wife of going after his money, and so and eventually they had some sort of legal settlement. With $100 million, ought to be enough money spread around for everybody to be happy, and so we never know exactly how it worked out. But anyways, kind of an interesting story. And of course, we all know about Britney Spears. That was in the news a lot this year, and And she was not the famous host of the American Top 40. Yeah. But this all started back in 2000, 2008. It was really in the news. She got divorced from a famous actor. I forgot his name. And she was acting erratically. The courts actually awarded the husband, the children, what they got 100%, was the husband, although she did have some visitation rights, and then she was found on TV having her kids in the front seat without any seatbelts. She had mental breakdowns, shaved her head, 5150 holds. Anyways, she had some real issues. So in 2008, she was granted a conservatorship, naming her father as conservator. Every single aspect of her life was controlled, and it was really amazing. And this story could go on for a couple of hours talking about all the things she went through. But she was prohibited from seeing really anybody else. She was medically forced not to have children. It was really abusive. On the other hand, during that time, she made, I think, $50 million, but it got to be pretty bad. And then I think about 3 years ago, there was a Free Britney movement, and the conservatorship was actually terminated last year. When you really get into this, it was really abusive. It really was. There was really no need. Somebody who has the ability to make money and so forth, should be able to make bad decisions. And eventually California passed a new law, AB 1194, the Britney Spears law, which added a whole bunch of requirements. For example, one of the horrific rules is if you were found to be conserved under a conservatorship, you didn't have the authority to hire your own attorney, because they would say you were not mentally available to do that. Well, that's crazy. You're kind of locked in this thing. So anyways, Assembly Bill 1194 changed all that, and there's a lot more new rules that protect the rights of a conservatee. So did the conservatorship help Britney Spears' life? Well, it might have in the beginning, but certainly went on way too long. And there's horror stories about the father making lots of money off her and so forth. One of the things that's come up over the past couple of years is a whole concept called supportive decision-making. And I've been to a couple of seminars this is the last couple of years, talking about this concept of supporting decision-making as opposed to a conservatorship. And I think we're going to see a lot more of this occurring over the next several years. This concept, and maybe it'll even get into, right now it's not, there isn't a legal definition of this, but it's a concept of letting people who are developmentally disabled have more control of their lives, but still there's decision makers that are guiding them through this. The concept is, people say, well, we don't want people who don't have the ability to make bad decisions. Well, how many of us have not made bad decisions in our lives? We all have. And so, I think you have a right to make bad decisions, I think, but we also want to protect the people that we love. Anyways, so we want to talk about conservatorships versus a financial power of attorney and healthcare directives. So which one to choose? Which one is appropriate? The reason we all care about this is the law presumes that if somebody is 18, they're competent. Due to various privacy laws, we find that physicians and financial people may not talk with you, and often will not talk to you. So we've seen that occur in the last 4 or 5 years, where physicians are just refusing to talk to people over 18. Let me rephrase that, refusing to talk to family members or somebody that's 18 or older. So here in California, we have 2 types of conservatorships, very different than any other state. So we have a general conservatorship, which is one which now these days is primarily geared for somebody who's elderly, dementia, cognitive skills. But here in California, we have what we call a limited conservatorship. And that is specifically designed for somebody with developmental disabilities, autism, cerebral palsy, Downs, these types of things. It's a horrible name, limited conservatorship, because everybody thinks that when they see limited, it's something less than a general, which is completely incorrect. The concept of a limited conservatorship is taking away 7 rights and duties from the conservatee and giving those to the conservator. That's where the word limited. I'm going to show you those here in a few seconds, but it covers just about everything you can think of. Okay. And speaking of, here's the 7 powers. And so the 7 powers: the right to fixed residence, where the conservatee lives, the right to access confidential records, the right to consult with marriage, the right to contract for limited, the right to contract for the limited conservatee, a powerful tool that would really prevent your disabled family member from signing contracts and getting hung up on that. Really, the right to give or withhold medical consent, the power to control the limited conservatee's social and sexual contacts, and the power to make decisions concerning the education. Very broad. I mean, it's hard to think of something that's would not fall into one of these 7 powers. And these are actually listed in the actual document, the letters that are finally awarded. So here and again, sort of the contraries. What are the powers of the conservator? When I put in DD here, the developmental disabled individuals. So decide where to live, confidential records, and so forth. This is kind of just the opposite thing, which these are the powers that are taken away from the conservatee and granted to the conservator. So what is conservatorship? It's the government taking the rights of one person and giving it to another. It's really serious stuff. And here in the United States, we have a long, strong history of independence and not letting the government to be oppressive. I mean, that's how our whole country was founded, on that concept. And so as a result, the process is very detailed and very thorough and can be very frustrating for a lot of people. Frustrating for us attorneys, really frustrating for people who are not familiar with the process. Essentially, the short version is papers are filed with the court, notification gets sent out to all the first and second degree relatives to that person. The court assigns an attorney to the proposed conservatee. So they have their own attorney assigned to them. That attorney does an investigation to determine whether they think that it's warranted. The court assigns an investigator who goes out and interviews the proposed conservators, usually the parents. They do criminal background checks. They'll talk to siblings. They'll talk to your parents if they're still around. It's a pretty thorough evaluation and a lengthy paper that's prepared. There's a report done by Inland Regional. Matter of fact, somebody, in order to receive a limited conservatorship, they have to be a client of the Regional Center Services. And then there's got to be what they call a doctor's evaluation on a special form called a capacity declaration. And finally, there's an actual hearing where it's an open court where anybody can walk in and publicly say, the judge actually says in court, is there anybody in court who objects to this conservatorship or to the people who have been named conservators? I've yet to have anybody ever stand up in court and say that, but it's just part of the process to protect the interests of the conservatee. It's a complicated process. So what I'm sharing here is our various steps to get a conservatorship. We actually send out, provide our clients a questionnaire that we've created. And then once that gets back, we prepare a whole slew of forms. All these forms are completed, filed with the court, and that's what kicks everything off. And once we file these forms with the court, they're assigning the hearing about 4 months out. During that period, probate investigators are reviewing all the documents, checking things to make sure that everything's checked right, or asking questions. There is the court investigators do their thing, which I just talked about. The attorney representing the conservatee does their investigation, and then a doctor's evaluation has to be obtained. That often is the most challenging, because trying to get the doctors to do an evaluation and fill out the forms, check the right boxes, initial and sign in the right spots. We spend a lot of time working through that. But here's just an example of all these documents that need to be completed. You can see there's a lot. And then once it's completed, and so when we finally get to, we go through this whole process, and then we finally have the hearing. The judge makes this announcement in court, and then what happens is, I think it's on here before, is letters are awarded, a court order and letters. So letters, it's a kind of an old-fashioned term, but the letters is a 2 or 3 or 4 page document that lists all those 7 rights, duties, and that's your authority you're the conservator. So that's who you would present to the doctor or the financial advisor, whoever, giving you the authority to make decisions on behalf of your disabled son or daughter.
So that's something that they would send, like, say, for instance, like a doctor's office, or like that way they would know that.
Yeah,
Yeah.
so the question was, are those the forms that you show at the doctor's office or other? Yeah, and the answer is yes. So now that we've gone through, what sort of questions do you have on the conservatorship process?
I don't see that.
We have 2 questions in chat, or 2 comments here. We are having trouble increasing the volume. Can you please instruct us? Volume is too low. Oh, I'm sorry. That you should be able to adjust your volume on your computer, and I will talk closer to my microphone, and hopefully that will help. Any questions?
Not really, but I kind of get all this process, and it's not gonna be like very pleasant. But what we care in a question is just in case something happened to us, I guess
Mm-hmm.
Or what happened
we
to
can
them.
survive.
And he's like
Yeah.
functioning,
Mhm.
so like a lot of this stuff he does understand.
But
Yeah.
he could really easily be
Gets
manipulated or manipulated,
distracted, or, yeah.
and that's a
It is. So let me go on and talk about the other option, and then we can get into some of the other questions. And so another option is don't do a conservatorship, but have your son or daughter do a financial power of attorney. In fact, all of us financial power of attorney, where you name somebody else to make financial decisions for you if you're unable to. You become injured or
That's good and look.
Yeah, but this is broad.
Yes, I know it's general information, I know.
and say no, I'll get to your questions shortly, okay?
Yeah.
So
Question in the chat.
okay. Let me check on the chat here. I would like information on AHCD. My grandson is 22 years old, Advanced Healthcare Directive. Perfect question, because I'm just getting into that, Mary. So I'll talk about that in a moment. So there's 2, and so if you don't want to do a conservatorship, the other 2 documents are a financial power of attorney and Advanced Healthcare Directive. Okay, and so what that is, that it's very comprehensive, very powerful. The problem is it's the disabled family's member. So the disabled family member has to understand, and what a lot of our high functioning members do, that they're giving you the authority to create that document. So the family must be competent to do that, must understand that what he's doing, and they can always cancel that document. Let's move on to the next document that addresses the healthcare, the Advanced Healthcare Directive. So this goes hand in hand with the financial power of attorney. So the financial power of attorney deals with financial activities. The Advanced Healthcare Directive deals with medical. And so again, you're naming somebody to make medical decisions for you. An extremely important document. We all should have that document in place. Some of you who've been around for a long time may remember Terry Schiavo. Terry Schiavo, this happened back in the 80s. So she was a healthy 26-year-old woman who suffered a massive heart attack, massive brain damage, had no documents set up. Her husband and parents fought for 15 years over who should make the medical decisions. Her parents said, oh, she wanted to live. Her husband said, no, she didn't want to live like this. 15 years of court activity. The politicians got involved. It got to be a big deal in the news way back. Eventually, the state of Florida came up with what they call a single purpose statute that said, okay, the husband has the authority to make that decision. But and the problem was nobody knew what she wanted. And that's the purpose for having the Advanced Healthcare Directive, is you can share what you want in that type of situation. And so anyways, my son, he's 36, he's pretty high functioning, cerebral palsy, but he gets around. He can go out to dinner by himself and pay the bill, and I think that goes pretty well. And I've always concerned about that. I always ask him about tipping, because that you have to do a little bit of math, right?
Always have to make sure that you tip.
Yeah, yes, exactly. And he goes to the movies by himself and so forth, but he has been subject to financial abuse, and we had some real problems with that. So anyways, but for him, I've not felt that a conservatorship is necessary for him, because he's pretty compliant, goes to the doctor when he needs to, he listens to us and so forth. So I've kind of felt that conservatorship really isn't necessary. So anyway, so what do you do when you're trying to make that decision between a conservatorship or simply go with the financial power of attorney healthcare? Obviously, the power of attorney advanced healthcare record, it's easy and inexpensive to prepare. It's very unlike a conservatorship. It's very powerful. The disabled family member can revoke the power of attorney at any time. The disabled family member can also just refuse medical treatment. So it's giving the authority out. The disabled family is giving authority to make the decisions, but not giving away his own right to say no. So that's probably the big thing that concerns a lot of people. So limited conservatorship, it certainly costs money. Our office charges $3,700. I'll talk about that in a moment, though. You don't have to use an attorney. It's powerful, but the disabled family member has no ability to refuse. Things to consider. Somebody who has a significant disability, they can't talk or speak or really think, you're really headed towards that limited conservatorship. If they're high functioning, compliant, and I think a POA, Advanced Healthcare Directive, may be just fine. I found that a lot of my clients with Down syndrome are usually happy and compliant, fairly high functioning. So we do a lot of these power of attorneys and healthcare directives for our Downs clients. Somebody who has some a mental illness combined with a developmental disability, I tend to recommend a conservatorship, because we found that the mental illness tends to get worse as they get older and they get more defiant, and yeah, we see that pretty consistently. We cannot do a conservatorship for somebody who only has mental illness. That is a special type of conservatorship called an LPS, and only the public guardian can initiate that type of conservatorship. It's frustrating for us because we have a lot of parents come in, their sons or daughters have some mental issues and are getting themselves in trouble, problems, drug use, all sorts of things. And it's very frustrating. We just don't have the ability to help
Like
those.
bipolar or
Exactly.
psychosis. doses or things like that.
Exactly,
Where they
exactly.
would in other, like a medication would seem normal.
Right, and that's that's a common problem. Is, somebody does have some mental illness, bipolar, those type of things, and they can take medicine to reduce the symptoms, but classically it makes them fuzzy and tired, and they don't want to take the drugs, and so it's a challenge. What other questions or discussions or might somebody have on this subject?
Her answers.
Um,
Oh, I think she's muted.
I don't see anything else.
Let me ask her to.
Okay. Oh, I see. She has her hand up. We need to unmute her.
I did. Asked her to unmute.
Maybe she's.
There you go. Go ahead, Mary. So you're still muted, Mary, or we can't really hear you. You're back muted again. Yeah, still can't hear you. I'm not quite sure why. You can certainly put any questions in the chat. Sure.
So, I get it's a consideration, I guess, like you said, in terms of, but for all intents and purposes, the financial power of attorney and the advance directive, that wouldn't necessarily be a conservative, right? Because I think a lot of people have that for whatever reason. I don't know why.
Well, so, it can, if you have somebody who is going to be compliant and do what you want, follow your instructions and so forth. It essentially is. The thing about it, though, is that they have to be comfortable with that. Secondly, they can always say no. So you can say, hey, you're coming in, we're going to take you for
I'm all right.
yeah, right.
I do have a question, it's just only to protect my son. So since he's a little, he's 22,
Well, sometimes.
sometimes he tends to want to play with little
Oh,
kids.
yeah.
Mm,
That kind of scares us a little bit because, all the person, oh, really, he's like, a man, the kid.
It
So
might be
how
like
we
he's
can-
like a pedophile and stuff.
Well, we don't want to think
Well,
that,
no,
but
we
there's got
don't,
some
but that's-
people might think.
That's the perception of his.
So how we put the kid from that?
sure. So, Mary, I'll repeat the question. Mary, can you hear me okay? You can nod your head. You can hear me? Okay, good. So I'll repeat the question. The folks here were saying they have some concerns about their 22-year-old son who thinks he's still a little kid and wants to play with other younger kids and so forth. And people might think he's a pedophile or so forth. And I mean, that's a problem. That's a problem. And so, how do you protect that? One of the nice things about having a conservatorship is that it's in addition to having the control, you also have a judge who and legal paperwork that says this person that is not competent to manage his own affairs, and therefore we will award a conservatorship. Where that can turn out helpful is if, let's say, somebody does call up the police and the police come over. Well, you can talk to the police and say, we have we have a
Yeah.
conservatorship, we have this paperwork, and I think you're gonna have a better response from the authorities and other people that you have legal proof that there's an issue there and you have the authority and so forth and so on. I've seen that quite a bit. So that's, I think, another powerful reason to have a conservatorship.
Yeah, a lot of these law enforcement people, they read into the person and they figure out that he does have some kind of.
We've been very fortunate, but we
But
do have,
it
yeah.
can be one that
Yes.
doesn't care and
Or that
that,
doesn't understand or, yeah.
Mhm.
and
because
that can
we-
totally hurt you.
Yeah,
Yeah, it's
it's a very big fear.
it is. And that's why I think and that's a common fear. I mean, I hear that a lot, whether it's that kind of a situation, or you can think of other situations that they might, get themselves in, not really in trouble, but
No.
make themselves visible to the police, that the police might think some sort of negative activities going on. And so,
Or-
We
parent or
try to
a-
teach
yeah.
him as much as we can, and he doesn't understand a lot.
Mm.
But his mentality doesn't allow it, because
Right.
when he wants to go and see little kids movies, which he enjoy, but we
Or
all
the Paw
three go.
Patrol,
But then
play.
if there's other kids and they start talking about the movies, and I mean, and he speak too, my son speaks too, so.
Yeah.
A
yeah,
lot of people, they say, hey, what if he's doing talking to my kid or something? They end up not saying that except for one person, but that's a big concern.
But
Yeah.
we're always on him, like one of us is always like next to him, or we try to, I mean, he's very independent
But we
too.
fully understand that it's
Yes.
his brain that
Yes.
doesn't allow it.
mhm. Yeah. So anyways, Mary, I know you can't hear very well, but anyways, they were just going on about their concerns with other people sharing concerns that their son was involved. One thing I wanted to also include, which is, how can you get a conservatorship? Well, you can hire an attorney to do that, but you don't have to hire an attorney. You can certainly do it yourself. And there's a lot of self-help out there where it takes you step by step through the process. And I've known quite a few people who have done it themselves. And if you have the time and energy and wherewithal to get through the court bureaucracy, you can do it. And like I said, a lot of people can do it. Another option is there are what they call LDAs, which are paralegals that'll actually prepare the paperwork for you. And they're certainly a lot less than what an attorney is going to charge. And I've heard some very good things, and I've heard some very bad things. I've heard people say that I've heard, I just lost my train of thought because I was reading that question.
Yeah, well, that's okay, we really don't mind or spending the money as long as we protect our kids.
Mhm.
We just kind of want to know what is the best for us, our situation,
course.
what is the best that we can do.
Of course.
So the question here from Mary is, I handle my sister's doctor's appointments, and she's 58 with DD, I assume developmental disability. And my dad is still alive, and says we don't need a conservatorship. So advanced healthcare directive would be best for both. What do you think? Well, so my answer is, if the advanced healthcare directive is working for you, and you're not having issues with dealing with other people, I would think that I would go along with the advanced healthcare directive. Again, as I was saying earlier, I have a financial power of attorney advanced healthcare directive for my son. It's worked out fine, and I've never felt the need for a conservatorship for him in my situation. So it's really fact different. So Mary, if advanced healthcare directive is working, keep it that way. Your grandson, okay, Mary also says my grandson, who is 22 and old and has autism and is nonverbal. Yeah, I think if somebody's nonverbal, you're probably looking at having to get a conservatorship, because if they can't communicate, they certainly can't sign the documents. They probably don't understand the documents, and that's probably what you're probably on that other end of the scale where you're going to need to get a conservatorship. we've just had one new person join, and I was just about to sign off. So we just had a Jason Yang join us. Welcome. We were actually just pretty much finishing up. But we have recorded this session.
Yeah.
We'll be posting this on our website. But Jason, if you do have any quick questions that I can answer, I'll be happy to try and address them.
Yeah, sorry, I just came back from work. It's kind of a traffic. I have a question. It's not related to this. I get a letter. My mom renewed her medical, and she also get a letter from the city, from the medical place that she asked her to apply the food stamps. So when people qualify for medical, also qualify for the food stamps?
That's an excellent question, and yes, that was a recent development. So once you qualify for a so let me talk about SSI a bit. So once you qualify for SSI, you automatically qualify for Medi-Cal, and up until recently here in California, you could not get food stamps. I think now it's called the SNAP program, but as of 2 or 3 years ago, you can. It's more bureaucratic paperwork to fill out. But you can, and I would absolutely take advantage of that. You need to fill it out, get approved, and use it. So what happened to me is we did it for my son, and he got approved for a grand total of like $15 a month. And so I just never got around to actually using it. And because we didn't use it, they canceled him out of the program. And now in order to restart it again, we've got to go through the whole application process. So if you do qualify and you get awarded food stamps, be sure to use them.
She put $15.
Yes, yes, $15. And that's another interesting aspect that I want to talk about is that, and I have a whole separate presentation on Social Security, SSI, how that works, the difference between SSI and SSDI and so forth. So I can get into that on another presentation, but the short comment I want to make is once you're on SSI, and then if the family, if the parents start collecting Social Security, then frequently the disabled person individual can graduate from SSI to SSDI based on the parent's income, and that could be substantially higher. And then once you're on SSDI for 2 years, you then qualify for Medicare. And so then you're on Medicare and Medi-Cal, kind of the best of both worlds. And Medi-Cal is pretty good. You know, there was a lot of concern about Medi-Cal, and doctors didn't want to handle Medi-Cal cases. That has changed dramatically. And so what has happened is in most of the counties, maybe all the counties, but certainly here in Riverside County, they've gone to managed care. So instead of just straight billing the government through Medi-Cal, there's 2 organizations here in the county, IEHP and Molina. And so my son went on, when my wife retired, for years and years, we had Toyota medical insurance. And then when they covered my son well past, right. And it was great. But when she retired, they cut him off, very concerned that about Medi-Cal. But we went on IEHP, we could go to the same doctor. And in fact, we'd go into the office together. I had to pay a $30 copay. My son was free.
Yeah.
So,
Yeah.
Mary, we got your email. We'll go ahead and add you to the email list.
And anyone that was on Zoom, if they could send their email so that we could send them for a free consultation.
Yes, that's right. So if you send in your email address to us, anybody who calls would like, we'll do a free consultation, and which I think we can provide more detailed information that would be more directed specifically to your situation. So please, if you can just put your email in the chat, and we'll put you on our mailing list. And then again, you can do a free consultation.
So here's one question, I don't know if it'll apply to any of these folks, but so like say in our case that we're in the middle of applying for SSI and, you know, we're working on that, but we were to get either a conservatorship or any of these other options, would that affect it? Would that hinder it? Would that?
No,
Yeah.
the short answer is no. The question was, by getting a conservatorship, does that affect my ability to get Social Security, SSI, or any of these government benefits? And the answer is no, not at all. It's two separate things.
Okay.
And then one of the things we have not talked about is we have not talked about special needs trusts and so forth, and
Yes.
that's a separate presentation on its own. But we'll talk about that, and having a special needs trust ties in directly with receiving government benefits, because money in a special needs trust doesn't count towards assets and that type of thing.
Oh, really?
Mary, concerning your question about receiving the printouts, we're still debating about whether we'll do that, but we are popular. Our intent is to populate more information on our website on this process. Any other quick questions before we shut down?
Hi, Jeffrey. I have a last question. When you said food stamps, when we apply that information, it's kind of confusing. I remember you said before, just consider one person in one household, right? It's not related to any other person, just one person, whoever applied the food stamp. It's just one person as one household.
So that's an excellent point. And I'm glad you brought that up, Jason, because whenever you're filling out any of this paperwork, whether it be for Medi-Cal purposes, for food stamps, whatever, what you need to do is, if you have a disabled family member who is age 18 and over, I know this is counterintuitive, but think of him as just a stranger living in your house. You're charging him rent, and that's important. You're going to charge him room and board for living in your house, and he's a household of one. So whenever you fill out that paperwork, just think of your disabled family member as a household of one. It's just the stranger that is living in your house. And it's so counterintuitive, because one of the questions in the paperwork is, are you going to provide housing and food for your child? And who would say yes? But of course, that's the wrong answer.
And that's why you probably get denied, then you have to appeal.
Because we forgot we have to do it anyway, so we do it.
Right, and then it affects the amount of money paid and so forth. So, okay, so I think that's it. One last, we saw one is the website on the flyer. You know what? Can you just type in? You have access to the chat, right?
Mhm.
So why don't you just type in
website.
the website for people to. It's basically Jeffrey C. Nickerson Law. If you type my name in, you can pretty much find me.
I was looking for the others.
You need to get it out. We're thinking of having multiple names. Okay, I want to thank you everybody for participating. I'm going to cut off our Zoom now, but I look forward to talking with everybody in the future.
Thank you.
Thank you.
Thank you.